Hey everybody, getting back to the complaint in the matter of Butler and Jesse versus McCoy, Porter, Henderson, Recess Lounge, and the Manioc Club. If we look to the right side of the page 3, we have in the caption, Court of Common Pleas, Philadelphia County, civil section, and then we have what appears to be stamped September 2016, and then below that the number 002107. That is the docket number, and that's the court term. That was provided by the Office of Judicial Records. If a case is filed in the Court of Common Pleas, in this instance in the 1st Judicial District, which is Philadelphia County, the document that we're looking at would have been prepared in the plaintiff's lawyer's office. They put it all together with the filing fee, and they send it to the Office of Judicial Records. They receive it, they stamp it, and now when it goes back to the plaintiff's attorney, now their job is to send it, serve it, deliver it to all of the defendants. If you think about it, it's only fair. If you're going to sue somebody, you've got to let them know what you're suing them for and when it all started. So that's how that works. I also wanted you to understand as well that I like this case because it's, got some pizzazz, but I also like it because it's not perfectly done. And I wanted you to see that there's a lot of different ways to do this so that you're not intimidated by the need to scrupulously stick to some forms. But anyway, for instance, you see where there's a line across the page under defendant, between defendant and complaint civil action. In any of these that I've ever done, I would always have complaint and civil action above the line and to the right. Also, the notice, which is below complaint and civil action, is a notice telling people, well, read it yourself. You'll see what it says. It's telling someone who's been sued, if you don't take action, this will result in something known as a default judgment. Default judgments happen when a defendant does not reply and the plaintiff gets what they ask for. So it's telling people in clear language, hopefully, that they have to do something, that they have to respond to this. I can tell you in practice, if someone comes to an attorney's office and asks them to defend them, oftentimes if the defendants were to call the plaintiffs and say, could we have a little more time, usually among attorneys, there's a courtesy that you'd certainly give people a little more time to answer. But look at the terms of the notice in there and see if you have any questions. It should be straightforward and it should tell people exactly what's going on. We scroll down further and we get to an introductory statement. Not all cases have introductory statements and often start with the parties. But in any event, when you have multiple defendants, perhaps it's easier to tell the reader that this involves, and look it over, you'll see what it involves. Basically, it's a beatdown at a nightclub, and they're suing the people that beat them up, and they're also suing the nightclub for not making it a safe place. If you invite people onto your business property where you're going to make money from people coming in, you have a duty to make sure they're safe. And in addition, this is a place that sells alcohol, and Pennsylvania, as do all the other 50 states, has what's called a Dram Shop Act. That's an old-fashioned term for the need to make sure, if you sell alcohol, that you don't serve intoxicated patrons. And if you do, you can often be held responsible for what happens once they get intoxicated. So that's the story with all that. Next, we scroll down to parties. And if you look at this list of people, it'll tell you who the plaintiffs are and where they live. It tells you who the defendants are and where they live. Basically just setting it out so that, again, you're getting a context for who these people are. If you look at paragraph number 7, it tells you that the Recess Lounge is not like the other people. It's not an individual. In this instance, it's a business entity of some sort. We probably don't know yet what type business it is, so they've covered it with the language business, company, entity, partnership, franchise. You get the idea. But basically, it spells it all out there. And the same is true with the Manioc Club. Then we get to facts. Now, what they've done in this case is set out facts that they're going to use later on in the case so that you don't have to keep repeating them over and over. So you'll notice, and I'll ask you to read this closely, but you'll notice we go through paragraphs 9 through, let's see where we get to here. We're in the 20s as I remember. Yeah, we get through paragraph 25. And if you look at all of those facts, check them out. They are basic, they are foundational. That means that they're leading you to the next phase of the case. And in count 1, we get to the assault and battery claim. Counts are separate individual claims that a person has. If you sue someone and you have 5 counts against them, maybe 4 don't succeed. As long as you have 1 that survives, you may be able to get a judgment based on that. So if you look at paragraph 26, that's a common device which says, by reference, we're including paragraphs 1 through 25 in this spot, so we don't have to repeat them all. And then if you read paragraphs 27 through, let's see where we go, paragraphs 27 through the wherefore clause right after paragraph 35, that's all of paragraph 1. And each of the paragraphs gets us a little further along, tells you what happened, tells you that there was a dispute over a bottle of champagne. If you're like me, I thought, what kind of dispute could be so important about a bottle of champagne? And then I learned that if the bottle of champagne costs $1,000, which I'm told it did in that nightclub, that's what the fight would be about. So anyway, it spells all those out. It spells out that these folks were the ones that were the proximate cause of these injuries. It tells that they've suffered damages. And then at the very last paragraph of that count, we get to the wherefore clause. A lot of students, after taking this course, will get a wherefore clause tattooed on their face somewhere. It's an important clause, has to be in all complaints. It has to be at the end of every count because each separate count can go to the jury. So if you had a case, and as I said earlier, some of them can be knocked out either during the early phases of the case. They could be knocked out at trial. The jury will still have things to decide if you have a count that survives. So that's the end of count 1. We sneak up on count 2. And if you'll notice in the background, I'm almost 8 minutes into this, and now I have a truck backing up with their sign. Okay, they've stopped, thank goodness. They mentioned civil conspiracy. When I said this was not necessarily a perfect complaint, in cases that I've seen in the past, usually on the very front page and in the caption, at the bottom of the names of all the defendants, you will usually say these words, individually, jointly, and severally. And what joint and several liability means is that if you get a judgment against everybody, let's say that the 2 businesses go out of business so they're not around, the person in this case that we're sure would have money to pay if they had to would probably be a professional football player that's pretty successful. So you sue them that way because it's considered to be a joint effort on everybody's part, so that if you obtain a judgment against all these people, you can collect it all against someone, any one of the people. So someone might say, well, all right, there were 4 guys, and what if we split it up 25%? No, it doesn't work that way. Jointly and severally means it was your intention to do this as a group, so that if you get a judgment against them, you can recover it against anybody, all of it. So that's all I'm going to say for now. Take a look at paragraphs all the way through, and I think you'll find it interesting. You'll see that it goes beyond civil conspiracy, and we'll do a little discussion a little further down the road. Thanks for listening.